again, not to beat up the state too much because Mr. Gomez just got on the case. But last I heard, they don't have it. It took us 4 months just to get the affidavits, the warrants, and that was darn near a year ago, Your Honor. So, Mr. Blackshear sit in jail. These are serious charges. Everything we're doing procedurally keeps him there because Investigator West or Officer West or whatever he is down there won't show up. So, respectfully, Your Honor, with regards to the motion to strike, I think I've made myself clear and I understand how the court looks at these things. I understand it's draconian. I'm asking for it to be stricken, but I understand the reality that the court's going to have to, or will probably do something other. With regard to the reasonable bond, we respectfully request that the court reinstates the other 2 bonds so Mr. Blackshear can bond out on this, I call it the DUI mess, which is the subsequent charge that he's been sitting in jail for now. As the time of this writing, which was February 9th, it was 519 days. So we're sitting on another 2 weeks beyond. And it's quite a long time to sit in county jail and wait on a witness judge. And again, we're trying to move the case, but we are bogged down, which is why we're coming to you today. And with that, I'll yield the floor.
Thank you. Mr. Heath, to answer your question, I have done my homework. I read through the motion to strike state witness, your motion to reinstate reasonable bond. I had read through that. Mr. Blackshear, when I nod, it is to show that I understand what he's arguing because I've read it in the motions. It's not necessarily that I'm in favor of what's being advocated, but I understand the argument and I understand the fact. To the state, Mr. Gomez?
Would you like me to address this? I think we've had discussions together, and I think given the state is not necessarily denying any of the representations about Mr. West, as Mr. Heath stated, I am fairly new. When I did come on, I wasn't able to get a hold of West. I do think, however, that there is well-settled case law that states that the sanctions need to be geared towards the witness and not the state. And I actually have a couple cases, if I may approach. I went ahead and highlighted the portions, but I'll discuss them with that very briefly.
Thank you, sir.
So
thank you for highlighting it too.
I think this case is pretty on point, just because in this case is actually a victim, and just for the record.
Giving me two.
Oh yeah, for the first one, I'm going to talk about State v. Gonzalez, and that's 695 Southern 2nd 1290. In this case, it was actually a victim that had been one of the victims that had been subpoenaed for a deposition. And the victim didn't show up, and a motion to strike that witness was filed. And I'm just going to go through and read kind of chronologically in my highlights. That case very clearly states that it is well settled that it is not the state's responsibility to produce a witness subpoenaed by a defendant for discovery purposes. I think even more on point, if you continue down to the second highlight, it says, even in cases involving policemen, witnesses usually aligned with the government, courts have refused to exclude officers' testimony for their mere failure to appear at discovery depositions. When asked to strike witnesses who fail to comply with discovery subpoenas, Florida courts have wielded that sanction with great caution. And then the last kind of highlight that I want to reiterate, in that case, the discovery violation was caused by the witness. For this reason, in the first instance, sanctions must be directed not at the state, but at the witness, with an eye to securing the compliance with the discovery requirement. The exclusion of a witness is justified only after some lesser sanction, such as contempt or a writ of bodily attachment, has been attempted without success in making the witness attend a deposition. The state is not, in the second case that I provided, merely kind of reiterates that. That's State versus Thomas, 93 Southern 3rd 1175. That just states the law is clear in this context. The exclusion of a witness is justified only after some lesser sanction, such as contempt or a writ of bodily attachment. Here, those lesser sanctions have not occurred. We are not necessarily arguing that Mr. West is a cooperating witness. The problem is that, based on what we've been told, he's not going to listen to us. The state, however, would request that this court this court basically give us an opportunity and help us try to secure this witness. And then if it doesn't happen, he doesn't show up, then the state will kind of do what needs to be done with respect to this case and that witness. But as it stands right now, the case law is pretty clear that there has to be some other lesser sanction before we get to this point where we're going to strike a witness completely. And so for those reasons, we would object to the motion to strike the witness. However, understanding the situation with Mr. West and understanding that that's primarily the reason why Mr. Blackshear is most likely still incarcerated and this hasn't been resolved, we would stipulate to the reasonable bond being reinstated. However, we want certain conditions in place based off of the situations in these cases and some of the concerns of law enforcement that would basically just secure that Mr. Blackshear is not going to be a problem to the community. Namely, we would want no access to firearms. We would want a GPS monitor. We would want very, very close supervision of Mr. Blackshear, just because these were some pretty serious instances and encounters that he had with law enforcement, and we want to ensure the safety of not only the public but also law enforcement if for whatever reason something else does happen once he is released.
Okay, so you're stipulating to the motion to reinstate reasonable bond if it's modified so that the defendant possesses no firearms and wears a GPS bond.
Yes, Your Honor.
Mr. Heath, as far as the motion to reinstate bond, any objection to those provisions to the bond?
No, Your Honor. That's my short answer. My long answer is that was a well-articulated position that I took when I opened my mouth this morning. I agree. I don't disagree that the striking the witness is draconian, but for the record and for my position, I have to shoot high, and that's what I've done. With regard to the bond, we have no objection to that. We have no objection to the weapons. Your Honor, you can notice from paragraph in the motion.
Mr. Blackshear still in the military?
No, he's not, Judge, and that's exactly what I'm referring to, is that Mr. Blackshear is not a convicted felon. Mr. Blackshear has a very, very limited criminal history. He has one charge from a carrying a concealed weapon in 2014 that was
okay,
dissolved.
Mr. Heath, you went on a long time, your first argument. I heard it over and over again. So
fair enough, Judge.
Is it changing anything regarding reinstating the previous bonds and modifying them for no firearms and wearing a GPS?
No, Your Honor. However, the new bond would probably have to include that as well.
What would be the terms of the new bond?
Well, I would request ROR since he's bonded out on the other two, and then the same conditions, no weapons, and if the state is insisting on GPS, I don't see the need for it. He's in close contact with me. He's never been a flight risk. He's regimented. He knows where to be and when to be there. GPS seems a little heavy, but I want the court to be satisfied with how we're doing this if we're going to have him out until we get this thing resolved.
Mr. Gomez, on the new bond, ROR and no firearms and GPS?
I think the state would be okay with that, Your Honor.
So the motion to reinstate bond is granted as follows. The prior bonds are reinstated. The new bond is an ROR bond, but all of the bonds, the original bonds are modified. The new bond will have a term of no firearms, and Mr. Blackshear will need to wear a GPS bond. Okay, Mr. Heath, your argument on the case, on the state's two cases that they presented, why shouldn't the court enter a writ of bodily attachment?
Judge, I would welcome it. Again, and you're right, I said it earlier ad nauseum that I get the strike is draconian and it's probably not appropriate in this context, but I still pled it that way because I want the court to be able to work downward. How it applies, I'll leave that to the discretion of the court. My concern is, just to speak candidly, Judge, is what's going to work. If this individual is thumbing his nose, and again, I reiterate, this isn't just what's in my motion. I've heard he's thumbing his nose.
Let me ask you this, Mr. Heath. Do I have to have, and I've noticed in both of the cases that were presented, it had a disjunctive or, says such as contempt or a writ of bodily attachment. Can the court jump straight to a writ of bodily attachment based on just his failure to appear twice after being served? Or do I have to give the officer or former officer the opportunity, does the court have to hold him in contempt before an issue of writ of bodily attachment?
It would be without having the proper research in front of me, but my visceral reaction would be holding him in contempt before you bodily attach him. That would seem the most pragmatic way of doing things within this court's discretion. I wouldn't want the court to overreach its discretion, and then we convolute this thing even more. It seems that would be the proper course if the court isn't going to do an order to show cause as to why he shouldn't be stricken. To me, that's the second best, but that's my position, Judge.
Understand. The court,
Judge,
hold on one second. I hate to say, grants the motion to strike witness, because what the court's going to do is enter an order to show cause for Preston R. West, order to show cause why he shouldn't be held in contempt, and then we'll need to schedule that for a hearing. The state attorney's office is directed to have that served on Mr. West, since the state attorney's office is the only one that knows where he is. And I understand, well, Mr. Blackshear's going to be out. That's good as far as the timing of the order to show cause. I want to make sure there's enough time to get him served. If we set it for April 10th at 1:30, why don't we do that? April 10th, 1:30.
Yes, Your Honor. Thank you.
And Mr. Heath, you'll prepare that proposed order.
Understood, Your Honor.
If you'll provide it to Mr. Gomez, if the two of you can't agree, Mr. Gomez, he'll provide Mr. Heath and me with a red line, and I'll finalize it in a minute.
And just for the record, I actually just became aware, I was unaware that he actually had gone to the Tampa PD. So I'm going to be working with my supervisor to see if there is not something that we can do in getting a hold of his supervisor with this order to show cause. And hopefully we can get something, but I just want to represent to the court that if we don't, the state is going to do what is necessary with respect to these cases. So.
Understand. Just a thought, and y'all do what is best for your clients. You may want, if you can, you may want to set aside some time to depose him if he's here for the order to show cause. Just a thought. When will I see Mr. Blackshear next, other than April 10th?
I believe it's March 13th, Your Honor.
Okay, March 13th for the pretrial?
Yes, Your Honor.
Do we want to continue it to the May 8th pretrial?
I think that would be
That'd be good, Judge. Get all this untangled.
Okay, so May 8th is the next pretrial, and April 10th will be the hearing on the order to show cause. Thank you, sir.
You want all four cases?
Judge, that's all I have before the court this morning. I appreciate the court's time. May be excused.
Yes, sir.
Thank you, Judge. Have a good day.
You too. A couple kind of housekeeping matters from me. Mr. Kleins, are you on the Smalls case?
I don't believe so.
Okay, it was State of Florida versus Swanana, Smalls. I mentioned it at the last hearing, or maybe before that, where it was an order granting motion to transfer the division. I got a proposed order for that, and there's no motion on the docket. So I guess the state is the one that's moving for it. So in 23, if one of you will write this down, 23 CF 375, it's State versus Smalls. I'm waiting on a motion to appear. Well, actually, let me just hand this to you if you don't mind, Mr. Gomez, and you can take it with you. I know whenever I'm handed something on the bench, it's easy to lose it. There just didn't any motion on the docket, and that's been in my queue to sign for over a week, and so I deleted it from the queue, and putting it on y'all's desk.
All right, thank you, Your Honor.
She's unrepresented, Your Honor.
Okay, thank you, Mr. Klein. To probation are in State of Florida versus Stout, which is 22 CF 3124. I received something I've never seen before. It has the style of the case, and then it just says, plea and sentencing agreement, done and ordered in Okaloosa County, and a signature line. So I don't know if y'all prepared this or who prepared it. I would suspect it'd be probation. Probation, you want to approach?
Yes.
Thank you. Mr. Durrell, you ready?
Yes, Your Honor. Hey, please the court, Dustin Durrell on behalf of Mr. Derek Wilson. Your Honor, we're here on a VOP asking for a continuance in this matter. This is the one where we're trying to get Mr. Wilson declared indigent of cost. I filed the motion. Mr. Wilson has filled out all of the applications. I've sent that to, I believe it's the JAC, if I remember my acronyms correctly. I'm waiting to hear back from them as far as whether they have an objection, so I can file for the hearing and include whether or not they oppose in the motion for the actual appointment of someone to conduct the evaluation.
Okay. It's been a while since I've had one of those.
It's my first time doing one, Your Honor.
If you will, if you don't mind, if you will call court admin,
Okay.
and they may not know in Okaloosa County, but they may. If they don't, then ask them for the name of somebody in Escambia in court administration. It used to be that there was one judge that was in Escambia County that was designated to rule on a lot of things like that,
Okay.
whether it's exactly this one or whether it's something else. But that judge may be designated to rule on all those matters where, I don't know if it's for consistency's sake, but that's been in place for over 10 years.
Okay, I will double check on that, Your Honor.
So how long do you want to continue Mr. Wilson's case?
What would be the next court date, Your Honor?
For miscellaneous?
Yes, Your
Is
Honor.
March 16th.
Like I said, Your Honor, it's my first time doing one. I don't know how slow JAC is. We can go out, and if I still haven't heard anything, we'll discuss what needs to be done at that point. I don't want to put it too far out and we lose track of Mr. Wilson.
Good. March 16th at 9 o'clock.
Thank you very much, Your Honor. I believe that's all I have.
Thank you, Mr. Drew. Yes, sir. Okay, Mr. Noakes. Good morning, sir.
Good morning, Judge. Yeah, on Mr. Spears' case, I have not heard back about getting him in Keaton. I've emailed twice, just don't get a response. I don't know if anybody's phone number. I don't have a phone number. I couldn't find one, so.
To the PD, do you have a number for Keaton
I have it at my office.
or probation?
I can tell the court that, and Mr. Noakes, that the contact person we deal with is a probation officer in Pensacola named Cindy Sewell. And Ms. Sewell previously had been very responsive to emails, and she stopped confirming emails when I started sending them to her, and I actually called Keaton a couple times and was told, oh yeah, she's already on the list to be evaluated. So just because she hasn't called back or responded doesn't mean that you just would have to call Janice Williams at Phoenix or Keaton and ask if this person's on the list. I don't know why Ms. Sewell doesn't acknowledge the emails anymore. But
Well, and I had emailed Janice Williams last time, I guess last week when we were in court, and she didn't email back, so maybe I'll just call her.
usually if you call Keaton, she's the one who answers the phone. So
Cool. I'll make that phone call. What's the next date that we can have, Judge?
March 16th
That'll be fine.
at 9 o'clock. If you get some resolution before that time, Mr. Noakes, I'll make time to accept that plea, or at least talk about it.
Absolutely.
Good. Thank you, sir.
I'll call over there today. Talk to you. I'm sorry. I'll try to get it done. Look, I can only do what I can do. I think I've got bias, but she's not an inmate at this point. I think she's in a program. I don't know how that happened, but I got an email or a phone call from somebody at some program in Pensacola that said it was reference her. But I don't know how she, I guess I should have looked at the docket, but I don't know how she's getting released from jail. It wasn't anything I did.
Are you coming back this afternoon? Do you have anything on the docket?
I don't have anything this afternoon. I got mediation this afternoon.
Okay. And this is the first time up from Ms. Bias on the VOP?
Second time, I think.
Okay.
She's got a pending case in Pensacola that, a petty theft case, I think, but it's a felony because of her record.
She denied the VOP on December 12th, and you did an oral motion to set bond on January 12th, and then Judge Brown set a $2,000 signature bond.
Oh, maybe she posted the bond, and now I remember that. Okay. So,
Your Honor, this is her second VOP. She had an FTA on the original case and an FTA on her first VOP, so if she isn't present, we request the habeas.
here's my note. She called and said she was going to rehab at Road to Recovery.
Okay. But Ms. Bias is the one that called.
Ms. Bias is the one that called.
Habeas will be issued for Ms. Bias, and the first appearance judge will determine the amount of the bond.
Judge, I'm going to contact Road to Recovery, and if I can get some information, I may file a motion to recall the case.
Yes, sir. And you may want to talk to the state if you find that out. The state may stipulate.
Absolutely.
Good.
Okay, thank you,
sir.
Judge. I'll let you know.
Judge, may I call somebody from Zoom?
Certainly.
Judge, may I call Destiny Wakefield, who is on Zoom? Ms. Wakefield?
Hello.
Hello, Ms. Wakefield.
Judge, Ms. Wakefield is set for sentencing in 21 CF 1826, and she is currently in an airport right now. She is traveling to get here, and she's facing cancellation. I can't say cancellation.
Yes, sir. Because of the weather?
I believe so. So I don't know how the court wants to address that. I know that she has been making efforts to get here for her sentencing. She's on supervision for a misdemeanor. We'd set this sentencing off today so that she could work on completing the conditions prior to Your Honor sentencing her today.
And I did read the violation report, and then just the first page of the plea agreement, which says it's a straight up plea. So what is the state seeking regarding Ms. Wakefield's sentence?
Judge, we were going to ask for 10 days incarceration. Ms. Wakefield has had ample amount of time to complete her requirements, and what my understanding is what happened is she was going to Bridgeway and got kicked out for not compliance because she didn't show up enough times. So at this point, that was a big sticking point for the state of that being the particular thing that she had missed.
Okay. Ms. Wakefield, not going to ask anything about the facts of your case. Let me wait on Mr. McKinney for that. Where are you now, Ms. Wakefield?
I'm at ATL Airport.
Atlanta.
Okay, gotcha.
Yeah.
When do you think you'll be leaving there? When do you think you'll arrive?
I'll be there this afternoon. I've been trying to get down there for the last 2 days, and I was on standby for 2 days, and then I got a flight, and then last night they canceled it because there was a ground wire bad in the plane. So they rescheduled us all for this morning.
And what time do you think you'll arrive here this afternoon?
3 o'clock, 3:30.
That's going to be difficult to make for her to get from the airport to here for her to make court today. Does the court wish to?
I mean, what does the state want to do? What do you request?
Judge, at this point, I would say we pass it for now, and then we can readdress it this afternoon. If Ms. Wakefield can let Ms. McKinney's office know whether she does make that flight, because it sounds like she's flying standby, so she may get bumped again. I'm not sure.
Ms. Wakefield, I'll certainly be at the courthouse until 5 o'clock, so I don't have any problem waiting until then as long as counsel does.
I have no problem with that, Judge. I just wanted to make sure the court was aware of what's going on.
Good. Ms. Wakefield, so I'm just going to pass your case until this afternoon. Stay in touch with Mr. McKinney, okay? Keep him up to date.
Yes, sir.
Thank you, ma'am. Hopefully I'll see you this afternoon.
Yes, sir. You will. Thank you.
As soon as you're getting on the plane, Ms. Wakefield, could you let my office know? And as soon as you land, could you let my office know?
Yes, sir. I will have the
Okay, thank you.
purchase. Thank you. That's great.
Okay. I don't see any other private counsel. Mr. McKinney? Yes, sir.
Yes, sir.
Either one of y'all, are you ready? What do you want to do next?
I'm ready for inmates, Judge, if the court is
Okay? Yes, sir.
ready for inmates.
Any other defendants in the gallery, Mr. McKinney, that you represent? Mr. Marley, you do?
I have a few, yes.
Do you want to do those?
I wouldn't mind.
Thank you. Or folks on Zoom, either one. So.
I do have, I think, 2 on Zoom as well.
Okay, good.
First, I'll call Mr. Troy McGill. Ryan Marl for Mr. McGill, Your Honor. This is 21 CF 2319 Alpha. The case is DOP. Without objection from the state attorney, the defense is going to ask the court to consider passing this to either a date in late April or early May. If the court will be willing, it's my understanding the sole allegation or the primary basis of the alleged violation is his failure to complete substance abuse evaluation and treatment. It's my understanding his appointment tomorrow with Bridgeway, anticipating needing 8 more classes, and that's the reason for this request, Your Honor.
Okay, and when does Mr. McGill's supervision terminate?
I believe he is at the end of his supervision, Your Honor, and that's the reason we're asking for this pass. The state's proposed resolution was to extend his supervision for an additional 6 months, but we don't have 6 months to extend. He's before the court on first-degree misdemeanor allegation.
Okay, that was why I asked, is to give him additional time, but if probation ends, I don't know, I think I lose jurisdiction. Probation?
Your Honor, he terminated November 12, 2022.
Okay, so to the state, do I have jurisdiction to do anything?
I would have to research that, Your Honor. I have to believe that you can. I can't think that you can't violate your probation just because the year is up and you just get off. I can't think that that's possible. I would have to research the issue there, Your Honor.
I mean, I think that you're right. I think once, as long as the violation of probation was entered during the term of the supervision, then I think you're right. But because it was a misdemeanor, can I sentence him to more probation?
I'm not asking the court to sentence him additional probation, and I agree with Your Honor that you cannot because he can't be given more than an additional term. But what I believe is that the probation is told once the affidavit is filed, and if the court would be allowed in continuance to finish this out, he's still on probation as long as it's told after the filing of the affidavit, is my understanding.
Probation, do you have any problems continuing to supervise Mr. McGill?
Your Honor, once he's passed his termination date, we're not actively supervising him, but if he gets a new law violation, we will notify him.
And he's been advised he is technically, until this is dealt with, still on probation until the VOP is gone. It's my understanding he's not actively reporting. You want to add something?
If you'll step away from the microphone and talk to your attorney first before you...
No, I'm okay.
Good.
We are here because I'm supposed to have finished Bridgeway, but because of the time in between, they made me start over. So today, I really believe I was supposed to be here telling you guys I was done, but because they made me start over, the time in between, I literally have an appointment tomorrow for my face-to-face, and then she assigned me 8 classes. So the whole thing was just to get the classes done, to resolve it.
So when will you be finished?
however long a class.
And that's why we're asking for the time, Your Honor, is because I don't know if it's one class a week or if he's asserted to me to see if he can
It's
take.
one class a week.
So,
Right.
So, I mean, I think early May would be, if he does a class a week, would be bond.
May 11th?
I would be okay with that, Your Honor.
Okay. So, Mr. McGill, I'll see you back here on May 11th at 9 o'clock.
Thank you, Your Honor.
and if I'm finished before that date, is there a way that we can,
If you talk to your attorney, he can talk to the state about terminating everything.
without having to?
Absolutely.
Yes, sir.
Just let Mr. Morrow know, and we will 100% get this going.
Thank you, Judge.
Thank you, sir. Who's next, Mr. Moore?
That'd be Ms. Nazamira Herring, Your Honor. That's 19 CF 1064 and 20 CF 38.
Oh my God.
Your Honor, she's before the court on a VOP in both matters that is purely financial. I have not been provided with a proposed resolution from the state at this time, but Ms.
It's over
Herring.
here. Sorry, I left it on your. Where? It was on the table.
I'll hear the say so.
Judge, my recommendation was going to be reinstate supervision for an additional 2 years. Automatic early termination upon completion of all requirements. Will continue to withhold. It's going to be the $100 VOP fee, $150 in public defender fees, and we'll agree to waive the cost of supervision.
Wait, just the prospective cost or the retroactive?
All costs of supervision, Judge. From reading the report, it looks like that Ms. Herring currently does not have her own place to live, and so based on that financial status, we would prefer that Ms. Herring focuses on finishing her community service work and paying off the other costs.
Okay.
Your Honor, I think Ms. Herring would like a little bit of time to talk to me about that offer. She's here today with a $5,000 payment to put towards the financials, which will only leave her with about $2,500 left. I'll ask the state if they have a position. Can she early terminate this 2 years? once everything's
She
done?
said yes.
Okay.
She said auto term. So Ms. Herring, from what I understand from the state's offer is your current supervision would be reinstated and extended for 2 years. However, it would automatically terminate upon your successful completion of all your terms of your supervision. And it's not adding anything to that other than the required $100 cost of prosecution, $150 public defender's fee. So it would automatically terminate upon you if money is the only thing that's left owing when you pay that money.
Your Honor, if the court requires a written plea.
No, sir, I don't.
Okay. And I think she'd like to enter an admission.
Ms. Herring, if you'll raise your right
Accept that,
hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, ma'am. You can put your hand up. Ms. Herring, so if I accept your plea, you're waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you. Do you understand that?
Yes,
And here's what the sentence would be. It would be continued withhold of adjudication. Your current supervision would be reinstated and extended for an additional 2 years. However, it would automatically terminate upon your successful completion of all the terms of your supervision. There would be an additional $100 cost of prosecution, $150 public defender's fee, and the state would waive all of your past and future costs of supervision. So is that what you wish to do? Yes, ma'am, is that what you want to do? Okay. Ms. Herring, I do accept your plea. Adjudication is withheld. Your current supervision is reinstated. It's extended 2 years, so the original terms and conditions are extended 2 years with an automatic termination upon your successful completion of your supervision. All past and future costs of supervision are waived. You'll need to pay the $100 cost of prosecution, $150 public defender's fee. Thank you, ma'am. Good luck to you.
Thank you. May I call some off the Zoom, Your Honor?
Yes, sir.
Ms. Samantha Jones, do I have Ms. Jones on
Ms.
Zoom?
Jones?
Yes.
Ryan Morrow for Ms. Jones, Your Honor. This is 20 CF 1323. The case is BOP. I've been provided with a written offer from Ms. Davis. May I relate some things to my client, Your Honor? I didn't have all of the details, and that's what we wanted to be clear. Ms. Jones, it's exactly as we discussed. The only issue that I see is the 7 to 7 curfew, and I'll bring that issue up with the court. But if you want to do this today and be reinstated, it will be to restore the supervision next 60 days as drug offender probation with a 7 to 7 curfew. I've discussed the curfew with probation, and I'll bring that issue up with the court. Is that what you want to do?
Yeah.
Okay. And Your Honor, I do have some concerns about the curfew, and I can explain that.
Okay. So it would be how long on drug offender probation?
60 days, Your Honor.
Okay. And the adjudication?
This isn't,
To the state?
I believe she may have already been
adjudicated.
adjudicated in this, Your Honor. I'm not sure.
I'll double check, Judge.
And then there'd be a $100 cost of prosecution, $150 public defender's fee.
It appears to me she was adjudicated on the underlying charge when she was initially placed on probation, Your Honor, if my file is correct.
Okay. So as far as the, 7 to 7?
Yes, Your Honor, and the only issue with that is she's fine with having a curfew. The issue is she works, I believe, at Taco Bell, Ms. Jones, correct me if I'm wrong?
Yes, sir.
And they keep odd hours. And then also, she is currently at a rehabilitation facility called Ever House, and sometime...
Sorry.
That's okay, what was it?
Evers House?
Evers House. And sometimes her treatment occurs after that 7 o'clock hour. And speaking with probation, it's okay that it's not 7 to 7, but what it must be is a 12-hour period where they know where to find her, essentially. So I just need to hear from Ms. Jones and have the court accept a different 12-hour period.
Well, if we did it 7 p.m. to 7 a.m. subject, probation then has the ability to vary that based on subject to work and the Evers. What is Evers doing?
It's Evers House, Your Honor.
Right.
It's an inpatient rehabilitation facility, is my understanding.
Treatment, right?
Yes, Your Honor.
Okay. Probation, any problem with that, if that was the sentence?
No, sir, we can adjust it, Your Honor.
Okay.
Ms. Jones, are you in agreement with all of that?
So I'll have 12, I can have 12 hours out. Is that what it is?
It sounds as though probation will be able to accommodate your work and your treatment, is what I'm hearing from probation.
Yes, sir, like if you get off, if you're gonna get off at midnight, then it would be a 12-hour from midnight to 12 a.m., 12 p.m. the next day. So it's a 12-hour period of curfew, but if we adjust it, it just shifts around and so that we still have the 12 hours.
Okay, so yeah, so that sounds good, because if the van leaves at 5 in the morning and then we come back around 10, that's within 12 hours, right?
5 and come back at 10 at night?
10 at night?
Yeah, that's 10 hours, or no, that's exactly 12 hours, right? Yeah.
That's more than 12 hours. A lot more.
Right, and this was part of my concern, Your Honor, is it sounds as though all the treatment occurs off-site, and then also she's working.
Does the treatment facility have a curfew?
Probation is requiring, and I see maybe that's the director or coordinator there, they're asking if, good morning, ma'am, if you guys have a curfew that probation can rely upon.
We do, our curfew is 9 p.m. The ladies are not allowed to work at night because some of our classes are on site in the evening, and then some of them are off campus in the evening. But everybody has to be in by 9, and if they're not at work or at home or in a legal setting, their meetings with their lawyers and things like that, then they have to be here. They also do a schedule like we actually use the Department of Corrections schedule that they turn in there every Monday. We adhere to it. We have like 60. We track them. They have to be where they're supposed to be, and they're made by me. We don't put up with any garbage.
How much longer is she in this facility?
Right. Do you have a timeline, Ms. Jones, for how long you intend to stay at Evers House? At this time, I know you just only recently got there. I don't know if you're still ascertaining that.
Well, I'd like to stay as long as I can to get, you know, I'm really doing good this time, you know, with my classes and the whole thing. So I have real good plans for my sobriety and being healthy and continue to work and paying off my probation. That's my goal.
A minimum of 6 to 12 months. The minimum for us is 6 months, and usually that's only when the 14th Judicial Circuit sentences them to us. The ones that are getting ready to get off probation before they send them off to prison, they come to us, but usually they stay about a year.
Understood.
Your Honor, as long as she's in that facility, then we can waive our curfew and abide by theirs.
You okay with that?
Yeah, or if she's in a facility, instead of doing just 60 days of drug offender probation, I think I would prefer just to say that she successfully completes this inpatient program, rather than, you know, having probation have to deal with drug offender probation and all. I mean, that would be the state's.
Okay.
Ms. Jones, did you hear all of that?
Supervision before.
Yes, sir.
Just remain in.
Are you on board with all that?
Yes.
Your Honor,
Yes,
based on that, we'd ask the court.
Okay, to the lady that is from Evers House, what's your name?
My name is Catherine McClellan.
Ms. McClellan, do you report to probation will you report to probation if Ms. Jones isn't?
We do, yes, sir. We do random drug tests. We've been open almost 8 years, and we work very well with Department of Corrections. Because our beds are limited, we don't have, we have waiting lists. If they're not serious about recovery, then we don't keep them. So we do random UAs, and if they fail, they're automatically, that day is sent to the Department of Corrections and the probation and parole officer. So then they can bring them in and test them. So yes, we do that.
Okay, thank you, ma'am.
So
let's start from scratch.
Yeah.
So it would be an adjudication of guilt. Her current supervision would be reinstated. She'd be on drug offender probation for 60 days.
No, Judge, I would say that we just do adjudication.
Yes, ma'am.
Reimpose her current supervision, reinstate,
Okay.
and successfully complete or continue to actively attend the Evers House drug treatment program, and reimpose all original terms and conditions.
Okay, and then there's a $100 cost for prosecution, $150 public defender's fee. Right?
Yes, Judge.
Ms. Jones, you okay with that?
That sounds pretty good. Thank you so much for I really appreciate you.
I don't know, you're breaking up, I'm sorry.
I said thank you so much for all y'all's time and effort and listening to my case. That sounds absolutely perfect. Thank you very much.
Ms. Jones, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can put your hand down. So, Ms. Jones, do you understand that if I accept this plea, that you're waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you? In other words, there won't be a...
Yes, sir.
Okay. Ms. Jones, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated with all the original terms and conditions. However, you will need to actively attend or successfully complete the inpatient treatment at Evers House. There's also a $100 cost of prosecution and a $150 public defender's fee. Okay?
Thank you so much.
Thank you, ma'am.
Okay, goodbye.
Yes, ma'am. Bye.
May I call another, Your Honor?
Yes, sir.
Mr. Dakota Collins? Do I have Mr. Collins on the Zoom?
Mr. Collins, you're muted. You can't go. There you go. Now we go.
Can you hear me now?
Yes, sir. Ryan Morrow for Mr. Dakota Collins, Your Honor. There's 3 matters before the court. They're all VOP, 19 CF 1313, 19 CF 1314, and 19 CF 1283. Mr. Collins, we didn't have the benefit of the state's offer when we discussed prior to court, but they have offered a guideline sentence pursuant to our conversation yesterday. May I rightly assume that you would like me to set this matter for an evidentiary hearing?
Could I please speak for a moment?
I would advise talk to me first off the record, but if you insist, I don't think I can stop you.
Is that okay with you, Judge, Your Honor?
Mr. Collins, I'd feel more comfortable if you and Mr. Morrow talk on the telephone in a little bit this morning, and then we bring you back. I just don't want you to say anything that may hurt your case, because everything's being recorded in the states here, okay?
I understand, Your Honor.
So,
I just wanted to bring up about how I completed all of my probation. I paid everything off, it's all paid in full, and I was given early termination, and something happened, and I'm dealing with it, but I'm fighting that somewhere else, but
okay,
I paid everything off, I did everything I was supposed to do.
Okay, I'd stop there. Anything else you say can be used against you, okay? So, Mr. Morrow, what do you want to do?
I'd like to set this matter for an evidentiary hearing, Your Honor. If the state changes their position or my client changes his, I'll alert the court.
So we're going to do it with subpoenas, correct?
That's my intention, Your Honor, based on my conversation with Mr. Collins yesterday and the state's offer.
Do you want it on March 16th? Madam Clerk, we're signed on March 16th?
There are about 40 defendants set on March 16th.
But this would be the afternoon at 2:30. Okay, what about March? Well, since Mr. Collins is out, how about April at 1:30?
You have nothing set up.
Okay, why don't we set it April 10th at 1:30? So, Mr. Collins, I'll see you here physically. You got to be here live, April 10th at 1:30. Okay?
Yes, Your Honor.
Thank you, sir. Mr. Collins, I'm going to call you as soon as I get out of the courtroom. Okay?
Okay, thank you.
Yes, sir. Your Honor, that's all I have on your morning docket. May I be excused?
Yes, sir. Thanks, Mr. Moore.
Thank you, Your Honor.
Mr.
You are leave now?
Yes, sir. Thank you.
Goodbye, have a good day.
You too.
Judge, I do have an individual on Zoom.
Okay, yes, sir.
That should be Kalani Sibley. Ms. Sibley, can you unmute your microphone?
Yes.
Ms. Sibley is on Zoom in 22 CF 3002. In that case, there is a 3-count information. Count 1 is a possession of controlled substance, less than 20 grams.
I don't have it on my docket.
It was an add-on for an early plea.
Okay. Okay. SIB.
SIBLEY.
And what's the case number?
22 CF 3002.
Thank you. Yes, sir. Now.
Ms. Sibley, if I jump to the end and come back, Ms. Sibley wants to enter a plea of no contest, accept the state's offer. The state's offer is time served. She does live out of state, which is why she's on Zoom. There would be $615 in court cost and a $150 cost of defense. She would be entering a plea of no contest and be adjudicated to possession of controlled substance, less than 20 grams of marijuana, a misdemeanor, possession of drug paraphernalia, a misdemeanor, and possession of controlled substance, third-degree felony for THC.
Has Ms. Sibling ever been adjudicated guilty
She
of a
has.
felony? Okay. Ms. Sibling, is that what you wish to do?
Yes.
Okay. Ms. Sibling, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, ma'am. You can put your hand down. So, Ms. Sibling, if I accept your plea, you're waiving your right. This is a new case, correct?
Correct.
You're waiving your right to a trial by jury. Do you understand that?
Yes.
Do you have any questions, Ms. Sibling, to the court, your attorney, or the state?
No.
Okay. Ms. Sibling, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. And that's to the misdemeanor. Well, there's 2 misdemeanors and a felony.
2 misdemeanors and a felony, Judge.
Okay. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. And then the $150 public defender's fee. What do you wish to do with those amounts?
Judge, we would ask for 90 days before they're sent to judgment.
So Ms. Sibley, if you don't pay those amounts within 90 days from today, then they will go to a civil lien or judgment, okay?
Ms. Sibley, you would make payment for those amounts at the Okaloosa County Courthouse if you come down here, or if you contact the Okaloosa County Clerk of the Court, then you would make payment through them.
Okay, so I have to make the payment in person?
You do not have to be there in person. You can call them, but you would call the Okaloosa County Clerk of Court.
So Ms. Sibley, give them a couple of days to make sure that they get the order before you call them, okay?
Okay.
Thank you, ma'am.
And if you have any issues, feel free to contact me at my office as well.
Okay, thank you.
Thank you.
I may approach with a score sheet, Judge.
Yes, ma'am. Thank you, ma'am. Yes, ma'am, sure. Thank you. Ms. Davis, I assume the equation ends with 0 as far as minimum time? Okay. Thank you.
Judge, this is Mr. Donnie Roop, ROOP, before the court in 23 CF 233. He said on the docket for a bond hearing. Prior to launching into that, we have spoken with the state, and I believe the state would be in a position to stipulate to a signature bond in this case, as we work towards a resolution trying to identify the restitution amounts. I don't want to put words in the state's mouth because they're certainly here and present in court.
So the $55,000 would be converted from cash or professional to signature?
If it's also included for pretrial services with no contact with the victim.
And no trespass at the victim's business.
Right.
Okay. And were those previously terms of the bond?
I did not see that they were previous terms of the bond.
Okay. What's the address for the no trespass?
Judge, he does contract work, so there was a storage unit that Mr. Roop was supposedly sharing with the victim, so.
Mr. Roop, the reason why I ask is I want to make really sure that you know what you can't do. Because if they later come back, the state says he violated it, I want to make sure it's all on record and preferably in the order.
I understand.
And make sure you know too.
Yes, sir.
So the victim is a DJ, Judge, so he does events. So what the state would be seeking is that Mr. Roop would not be trespassing at locations where the victim is doing those events.
What if you said no contact with the alleged victim and can't come within 500 feet of the alleged victim?
Yes, Judge, that will work.
Okay. Mr. Roop? Well, to your attorney, do you have any objection to that?
No, Your Honor.
Mr. Roop, so your bond is modified so it's a $55,000 signature bond. If you don't show up when you're supposed to show up, if you violate the terms of the bond, then you're going to owe $55,000. The court does appoint pretrial services. You'll have no contact with the alleged victim and not go within 500 feet of the alleged victim.
The next court date for Mr. Root while he's here is going to be March 16th, which is a felony plea day at 1:30 p.m.
Okay? March 16th at 1:30. I'll see you then.
Yes, sir.
Thank you, sir.
Thank you.
This is Mark Sally.
Thank you.
Judge, this is Mr. Mark Sally before the court in 11 C-1568. And Judge, I was appointed last week to Mr. Sally's case, and to bring the court back up to speed, the state made an offer of 120 months in department in reinstatement of Mr. Sally's probation. He has a substantial amount of Department of Corrections credit The last thing that I really want to do is go through a score sheet and discuss that with Mr. Sally. I've been trying to piece together the old one here in court. We spoke yesterday at the jail about the state's offer, and I believe we're in a position to try to move this thing along. I'd like to bring him back at 1:30 today so that I can have a time in the courthouse to go through a score sheet with him prior to us announcing our intention to enter a plea today or ask for additional time.
Okay. Mr. Sally, I'll see you, well, 1:30 we have arraignment, so it'll be 2:30.
2:30.
Mr. Sally, I'll see you at 2:30, and I'm sure Allison's going to tell him to keep you here. Thank you, sir.
Next is Zachary Willis.
Thank you.
This is Mr. Zachary Willis. Mr. Willis is approaching 21 CF 2708 and 20 CF 1450. He also has 20 CF 3102. The 20 CF case numbers are felony violations of probation. The 21 CF case number is a new law offense. Mr. Willis has been returned to us. He is in federal custody. He has been sentenced in federal court to 10 years. So at this point, we have tentatively reached an agreement for Mr. Willis to resolve his state cases to get him on down the road to the federal end. But I'm asking you to come back at 1:30 as well. Given the nature of and the amount of counts here, I'd like to put this on a written plea agreement for Mr. Willis to sign.
Yes.
And we've reached the agreement in court today. I'd like to come back at 1:30 to enter that.
At 2:30.
2:30.
Right. Mr. Willis, I'll see you this afternoon at 2:30. Thank you, sir.
Thank you.
Next is Jolene McBride.
I'm here all day, so I hope those are the sheets.
Sorry, Your Honor, I was just explaining to Ms. McBride her financial obligations. Your Honor, I did meet with Ms. McBride at the jail yesterday. We do have an agreement to resolve these three cases. At this time, Ms. McBride in 23 CF 262, today is 223, would be entering a no contest plea as charged. On that particular case, Your Honor, Ms. McBride would be placed on 6 months of community control, which would be followed by 2 years of regular probation. Special condition of supervision would be that she is going to begin substance abuse treatment with Bridgeway as a condition of supervision. There will be, the court will reserve restitution, or will reserve jurisdiction for 90 days on the issue of restitution. There will be $610 in court costs, $150 in public defender fees. There will be an automatic early termination at 12 months if all of the special conditions and conditions of probation have been met. In both of the VOP cases, these were both originally pled to misdemeanors. So in 22 CF 1354 and 22 CF 2627, Ms. McBride would enter an admission to violating supervision. She would be reinstated to supervision in both cases concurrent with the new term of supervision in 23 CF 262. She'd be assessed a $100 cost of prosecution for each of those VOP cases, a $100 public defender fee for each of those cases. The state has agreed to a withhold of adjudication, and Ms. McBride is going to ask the court to authorize her to do community service in lieu of any available court costs, so she could do that.
Okay? Yes, sir. Ms. McBride, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, ma'am. You can put your hand down. Ms. McBride, did you read the plea agreement?
I did. That's
Do you
why I just
understand?
asked a bunch of questions.
And I heard you say, what does this mean right here? And so that's great. I'm glad that you do that. Because, you know, this is your life. I mean, I'm glad that you've read through everything and that you understand it. So do you understand everything that's in this plea agreement?
Yes, sir.
Did you sign it?
Yes, sir.
Did your attorney answer all of your questions?
Yes, sir.
Are you satisfied with this representation?
I already am. Yes, sir.
The only thing that's not on that plea agreement, Your Honor, is the reservation of jurisdiction. I just didn't want to clutter it up.
For restitution?
Correct.
Okay. Ms. McBride, I do accept your plea. Adjudication is withheld. You're sentenced to 6 months community control. This is on the felony count. 6 months community control followed by 2 years of probation. However, your probation will automatically terminate at the 12-month mark if you've successfully completed all the terms of your supervision. You'll need to submit to or go to substance abuse counseling at Bridgeway. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution if the state files a motion or a petition within 90 days from today. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. There's a total of $350 in public defender's fee. And on the misdemeanor, your current supervision is reinstated. All of the sentences are to run concurrently, run at the same time. There's also two $100 cost of prosecution. Thank you, ma'am. Good luck to you.
Your Honor?
Yes, ma'am.
Can you ask what town she lives in?
Yes, ma'am.
Okay, the minute you get out of jail, please report immediately to the probation office at Berkeley
Judge.
County. Because you're on community control.
There were two cases, I told Mr. Cotton, one of the cases I told Mr. Cotton I would ask you and get back with you. We had filed a stipulated motion to continue as the officer that was here for a motion to suppress. He actually is in training and is unavailable. I got with Mr. Cotton and I believe we filed that motion. Unfortunately, it was late. We did file it yesterday. Mr. Cotton stipulated he just needed to know if he needed to appear this afternoon. That's one, and the other one is a case that we can go ahead and get off the docket because we're going to be
Okay, let's start with one, Mr. Cotton. That's
Mr. Peters.
Peters.
Yes, Your Honor.
I did see that, but I didn't see, a proposed order for y'all.
I will get with Shirley, Joe, and make sure that's sent over to you.
I saw the state's motion for continuance, and in that you stated Mr. Cotton had no objection.
Yes.
So that is granted. So the motion for continuance in State versus Peters, it's 22 CF 1393 is granted. When are we going to continue that until?
I believe in the order that I had drafted, and I apologize that it wasn't sent to you. I believe I said March 16th was that date, but I just heard that it was really busy. So I would have no objection to moving it to maybe the March 23rd, if I'm not mistaken. That's the next day.
There is one. I'm going to do it March 23rd that afternoon.
I think that would be ideal, Your Honor.
Okay, so at 2:30 on March 23rd.
Did you still want it set for the 313 pre-trial conference?
I think if we wanted to move it to, I believe it was the May 8th or
right.
April,
May.
I'm sorry, May 8th.
Yes,
yeah, then we can do that and that way it'll track.
If you'll make sure that you've got the March 23rd date in the proposed order. Thank you.
Oh,
wait, you had one other.
There's just one more, just so I can get Mr. Morrow out of here.
Right.
It is Tristan Choate. He was on for a Docket Evidentiary. We were holding it because we needed him to get his medical marijuana card. We told him that if he did, we would dismiss the DOT. We had to improve that, and so we're going to be dismissing the DOT in that case.
Okay, so the VOP is dismissed in 19 CF 192. It's Mr. Choate, CHOATE. Is he still on supervision?
He is.
And he'll be advised, it's actually two matters, Your Honor. I have 19 CF 192 and 20 CF 1009.
Okay, yes, sir. Thank you.
Would it be all right if I called Mr. Choate and let him know they did not need to be here today?
Absolutely, yes.
Thank you, Your Honor. Now with that's all I have for the day.
Good. All right.
I guess I'll see you folks in March. Thank you, Your Honor.
Thank you, sir.
Thank you, Judge, for allowing us to do that.
Excellent, thank you. Great, yeah.
Billy.
Billy Lane. Billy Lane is on.
Your Honor, this is Billy Lane. He is present and approaching. Unfortunately, I didn't get a chance to meet with Mr. Lane when I was at jail yesterday. I did not know he was in jail at the time. So today, I'm going to enter a not guilty plea in 23 CF 195. I know it's kind of on the fly, but Mr. Lane clearly has some medical conditions. He just relayed to me that he's supposed to be getting surgery at one of the VA hospitals. Ultimately, probably going to end up at the Andrews Institute in Gulf Breeze. I would ask the court to consider passing Mr. Lane to the afternoon so I can write a quick bond motion for him to see if we could get him possibly released on a bond here.
Can you give me like 1 minute and let me just look up something? I might be able to stipulate to that. I just want to.
Sure, absolutely.
I can hold him in the video.
If you guys want to do that, that's fine. I'm going
If you only need a minute, then let's just
Okay.
let Mr. Lane. He's okay standing. Mr. Lane, you need to sit down.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. This
Your Honor, I believe the state would stipulate, there's a $1,000 cash or professional bond for Mr. Lane right now. This is a situation where he's accused of essentially driving one of the mobility carts at Whole Foods across the street over to the Best Buy. He scores 22.2 points. We would ask the court to reduce that $1,000 cash or professional to a $1,000 signature bond so that Mr. Lane can be released and attend to his medical needs.
Yeah, and the state stipulates to that given the medical situation of the defendant.
Mr. Lane, so you'll be able to sign out of jail today. There'll be a $1,000 signature bond. You don't show up when you're supposed to be, or if you violate terms of the bond, you'll owe $1,000. When will I see Mr. Lane?
He's set for pre-trial on 3/13, Your Honor.
Okay. Do we want to keep it on 3/13?
I would ask to continue it to the May docket, so.
Any objection?
No objection.
Mr. Lane, so I'll see you on May 8th at 9 o'clock, okay? May 8th at 9. Thank you, sir.
But I need you to call me, okay?
$1,000 signature. Yes, ma'am.
So this is your next court date. That's your next court date. Let me get you a card, okay? And call my office.
Next is Mario Lee Jr.
Thank you.
That's what you're doing. I'll show you. Worry about your health first, but call me.
Well, Mr. Lee. Good, how are you? Mr. Lee, well, is there an offer to Mr. Lee that he may want to accept today, or should I appoint the public defender?
Your Honor, this is going to be a minimum mandatory guideline, or likely going to be a guidelines offer, but there is a minimum mandatory attached with the charge, so I would think it would be in the best interest of the defendant to appoint the public defender.
Mr. Lee, would you like for me to appoint the public defender if you qualify financially?
I'm working on retaining the attorney right now, Your Honor.
Okay, so Mr. Lee, you're charged with theft of a firearm, possession with intent to sell, manufacture, or deliver a controlled substance. Also, drug trafficking and fentanyl, 28 grams or more. That's why you're here. So you're going to hire a private attorney?
Yes, sir.
Okay. So is Mr. Lee's, is his next date March 13th?
That is correct, Your Honor.
So Mr. Lee, I'll see you back here March 13th at 9 o'clock. If you're going to hire a private attorney, do it sooner than later so that they can talk to the state, start working on your case. On March 13th, I'll be talking about setting it for trial. Okay? At least we'll work toward trial.
Yes, sir.
Okay? See you then. Thank you, sir.
Thank you, James Pittman.
So, Mr. Pittman.
Yeah, this is Mr. Pittman. We did file a motion to reduce bond in that case. It's been noticed for hearing today. In terms of the actual arraignment, there's a 3-count information. We will enter a not guilty plea, waive the formal reading. I don't know if the court wanted to do the bond motion now or this afternoon. It was noticed for 1:30.
I haven't, it wasn't.
I haven't seen
didn't see it on
any,
the
I haven't seen
document.
any of this, yeah, so.
We can come back and do it this afternoon.
Okay.
It's a one-page motion, Your Honor, so.
So, Mr. Pittman, I'll see you this afternoon at 1:30, okay? Thank you. Anybody else in back? Nobody else in back?
No one else in the back.
Okay, do we have anything else for this morning that we can do or want to do?
There's one thing that we can do. It's Mr. Jason, I'm sorry, Brian McKinney, Your Honor. Yeah.
2:30 or?
He's technically on the 2:30, but I think Scott knows what I'm about to do, so he would rather handle it now. Yeah, he doesn't really need to be here. We're dismissing the new law that was the 4622 CS 002719. We had repeatedly tried to get up with the victim. The victim was also going to be the witness in the Evidentiary that we had. I found out that there was a circumstance which I had been lied to about the victim's condition. And so for those reasons, I haven't been able to get up with him. I left multiple voicemails. We're going to be dismissing the 4622 CF 002719 and dismissing the DOP on the 22 CF 1223. And Mr. McKinney will be back on supervision.
Okay, what happens to the 22 CF 2719? You're dismissing that?
That's dismissed, Your Honor.
Okay, so that case is dismissed. And the DOP on 22 CF 1223 is dismissed.
That's correct, Your Honor.
So he's still on supervision?
He is still on supervision.
His term date, Your Honor, if I recall correctly, is like 2024 or 2025.
Yes. Yeah, it is.
So, Mr. Carnes, you'll let Mr. McKinney know that he's still on probation?
Well, he's in the jail.
Do we need to have him transferred?
I would prefer that he be transported just because I don't want him hitting the street and not.
Right. I think that'd be best. Yes, sir.
But as soon as he's here, I can inform him, and then we don't even have to bring him out if the court wants.
Okay. And you'll let him know that he needs to report to probation?
Oh, yeah, I'm gonna get some paperwork from probation and say this is where you need to go.
Good. Excellent. Okay. Anything else we want to do this morning?
So there's someone in the back. Sir, you want to step up?
Yes, sir. Yes, sir. What's your name?
Eddie Hudson.
Hudson?
Yes, sir.
Mr. Hudson is my client. I believe that he was transferred from another division into this court, and I believe that there was a reason for failure to appear in court, if memory serves me correct.
Do we know a case number?
I'm on the spot, so I don't know the...
Okay. Mr. Hudson, what's your first name?
Eddie Hudson.
Eddie? Okay. Madam Clerk, will you call me?
Eddie James Hudson.
James?
Yes.
23 CF 174.
Good. You're fine. Mr. Hudson, let me look at your case, okay? One, Mr. Hudson, failures to appear, you being here means a huge amount to the court. You voluntarily being here, so relax a little bit, okay?
Madam Clerk, you said it was 23 CF 174? And Judge, it looks like there was an order transferring from Division 1 to Division 2. The court date was reset, and it looks like Mr. Hudson did not appear at felony plea day on the 16th, which was last week.
So, Mr. McKinney, what do you seek?
I'm asking the court to withdraw the capias and allow us to enter a plea of not guilty to the two-count information.
Any objection from the state?
No, Judge.
Okay, the capias is withdrawn. Mr. Hudson said they won't arrest you today.
Thank you.
Will I see him on March 13th or at the pretrial, or when do we want to set it?
Judge, it is set. Madam Clerk, if we set it for March 13th, is that where it's going to land? Judge, if we enter a plea of not guilty, waive formal reading of the two-count information, and ask for this to be set for the March 13th pretrial docket.
Okay, so, Mr. Hudson, I'll see you back here March 13th at 9 o'clock. Stay in touch with Mr. McKinney.
Hello, yes, sir.
Thanks for being here voluntarily.
No pleasure. Thank you, sir.
Thank you, sir. Anything else? Yes, ma'am.
Your Honor, I was having some problems e-filing yesterday, so I do have a sentencing letter, that's probably like a page on Mr. Mochel that I need to file this morning, as well as a response to defense's brief. So as soon as I get back to the office, I'm going to e-file that, and I'll email it both to Mr. Klein's. And would you prefer just directly to your email?
Absolutely,
Okay.
yes, ma'am. If it's anywhere close to the day of the hearing, email it directly to me where I can do my homework.
Yes, sir.
Good. Okay. Anything else we can do this morning? Probation is smiling. It's a good thing. Okay, thank you. We're in recess until 1:30.
All rise.